This is LXBN TV, and I'm Colin O'Keefe. Merrill Lynch just recently agreed to pay $160 million to settle claims of race discrimination, a figure that's almost unheard of in today's discrimination class action landscape. Joining me now to offer an explanation and also share his thoughts after just joining us on LXBN TV recently is Jerry Maatman. He is attorney with Seyfarth, where he is co-chair of the firm's class action practice group, and he is currently lead counsel on 3 of the 5 largest EEOC cases in the country, and he is also editor on the firm's workplace class action blog. Jerry, first, can you explain the basics of the case and why it's seen as a bit of an aberration in the modern class action landscape?
Sure. I think another word might be extraordinary. The decision from February of 2012 by the Seventh Circuit created a distinction that allowed this employment discrimination class action to survive the Supreme Court's ruling in Dukes. Dukes, of course, said that when personnel decisions are made by many managers, there's no glue that holds together these thousands and thousands of personnel decisions. The McReynolds versus Merrill Lynch case involved 2 personnel policies. One was the selection of financial analysts to be on teams to broker accounts. The other was how to divvy up and distribute accounts when financial analysts left. And despite the fact that the district court in the litigation had denied class certification, saying this involves thousands of discretionary personnel decisions, and under Dukes the case can't be certified, when it went up on appeal to the Seventh Circuit, it certified the case, which is extraordinary in and of itself. Usually, Court of Appeals will remand a case with instructions for the district court to enter orders consistent with the Court of Appeals decision. But in this case, the Seventh Circuit said, we, looking at the record, will certify a case. In this instance, a very narrow certification, what's known as issue certification, on liability only. And within about 18 months after some additional discovery, the case settled for $160 million.
Wow. So second, what are the implications for employers here? Is this truly just an aberration, a blip on the radar more or less, or do we need to rethink this post-Walmart v. Dukes world of class actions?
I think it creates problems on both sides of the table for plaintiffs and defendants in terms of the takeaways. I see 2 key takeaways. The first is it shows the dangers when plaintiffs' attorneys calibrate a much narrower case involving issue certification. Certifying a class is the holy grail in these sorts of cases. And to the extent plaintiffs' attorneys bite off too much that they can chew, try and make the case too broad and involve too many people or too many issues, it plays right into the hands of employers trying to oppose and defeat class certification. But the McReynolds case shows that a very narrow issues only certification class can, in the post-Dukes world, be certified. So one of the things I would expect the plaintiff's class action bar to do is to use it to try to craft much more narrow classes to maximize their ability to certify a case. The second takeaway is the blockbuster number, 160 million. That is by far the largest class action employment discrimination settlement post-Dukes. It's actually the 6th largest settlement all time in an employment discrimination case, and typically success begets copycats, so I would expect it to embolden more plaintiffs' lawyers and more plaintiffs to sue and to bring these sorts of employment discrimination cases, which in the post-Dukes world many thought would begin to die on the vine. So I think those are the two key takeaways we're going to see from both the ruling and the settlement.
Very interesting. I don't think we'll have to wait too long to see the impact of this because, as you mentioned, there's bound to be copycat class actions, and we'll have to see if other courts handle them in the same way that the Seventh Circuit handled this one. Once again, that was Jerry Maatman of Seyfarth Shaw. For more of his insight on this case and other cases that are similar, be sure to visit workplaceclassaction.com. And of course, if you're not already watching us here on the new look LXBN, be sure to visit lxbn.com, where you can of course find hundreds of these LXBN TV, video interviews, and curated commentary from the LexBlog Network's more than 8,000 members. Thank you for joining me today, Jerry.
Thank you.